thank you very much for inviting me to talk today. And the session now is themed around inclusion and exclusion. And of course, I think everyone here has picked up by now that I'm an avid reader of Luhmann. And Luhmann tells us whenever we try to include anything, logically that leads to an exclusion. There's no container that can include completely. There's always an outside. And try as much as we want to include more, whichever inclusion criteria we use is going to lead to another kind of exclusion, maybe one we didn't foresee. So keep this perhaps in mind as a leitmotif as I talk about my topic today. So I wanted to, when I was asked to speak about algo norms, I thought I'm not someone who's into IT law, cybersecurity, or any technology, things like that. So I wanted to play around with the concept and take a bit of creative freedom with this idea of algo norms. And the first thing, and I know we have people here who've read Matteo Pasquinelli and so on, but the first way I want to set the table first is to say that, of course, algorithms are not something brand new. Neither is the law, neither are norms. They both have ancient origins, and perhaps an origin that is very much connected. We can think of them together. Law in itself, if we go back to our earliest surviving law texts from the ancient Mesopotamian civilizations, legal sociologists and legal historians already recognized a certain pattern in these codes of Ur and Hammurabi's code and these things, in that there are different terms to explain it. One is that it always takes a casuistic or a conditional form. I'll stay with the term conditional for today. But ancient laws had a form of if X, then Y. If your neighbor steals your cow, then he has to give you 2 cows back, or whatever, or his eye gets poked out, or whatever the case may be. This basic form has existed for millennia, and many, as we will see, would say that even today, our most sophisticated laws can still be boiled down to this simple conditional form. But algorithms, so there's something algorithmic in that procedure of law, in that we have certain conditions, we apply this legal formula, and we get a result. And we keep going on like that. So law has this form, and it applies algorithmically and applies to its own results for thousands of years. People like Pasquinelli have argued outside of law that algorithms have also existed already in ancient times. One example is in ancient Rome, the festival of Terminalia, where the citizens would circle the boundaries of their town or their empire, doing certain rituals, and what this did was consecrate those boundaries, reaffirm the polity, reaffirm the law. And this kind of algorithmic procedure is in its basic form still what we see in digital algorithms. Now to turn to Luhmann. So Luhmann says that decisions can be based, we can make decisions in one of 2 ways. He calls these decision programs. The first, is conditional programs, which is very much how law works. We look to the past, we see if certain conditions are met, we make a decision in the present, and we carry on with our lives. This is the old conditional form that we know from law. The other one is a purposive program, where we look forward to a certain goal, and in the present we make decisions based on what is most likely going to get us to that goal. Here's a chart. So the present is the present. In conditional programs, we have certain triggers. If my neighbor steals my cow, we know what kind of decision to make. Purposive programs work with unpredictable goals, and we have to constantly, as the present progresses and we get further towards or further away from our goal, we change how we act in the present to orientate our organization or our life or society, whatever. And Luhmann says that law cannot operate on purposive programs. The law, and I think this is, especially in my country, something that we've been experimenting with, and perhaps it wasn't a good idea, but the idea that law can guide us to a certain utopia. Luhmann is very critical of this concept because law has to look at the past. I use the example of South Africa now, saying we've been experimenting now with a purposive law, but perhaps this is something that's more global. There's a very obscure quote of Luhmann's that I found that I really like, actually. If our society had to agree on a symbol, it probably would not be the circle, nor the cross, nor the line, but the spiraling exponential curve. Society is obviously getting more and more complex. The problems that arise out of this complexity are numerous. Technological, of course, as we've spoken since yesterday. Environmentally, of course. This has, I think we can understand this under the rubric of Beck's risk society. However, I think from the 80s, when this German sociological of risk discourse around risk was at its peak, perhaps we've even in the 30, 40 years since then, this has become much more apparent, much more shocking to us. And in terms of the size, the scale, the magnitude of these risks. That's why I play a little bit. And actually, I saw you also used, I thought I invented the term, but your paper includes this where I talk about hyper risk. So I say I didn't put it in the slide, but Timothy Morton, the ecologist, talks about hyper objects, things that are so large and dispersed in size that they take on this hyper size that we can't fully comprehend. And I say we also have hyper risks now. It's too vast for us. Now, what are the problems from the legal point of view? Maybe from other points of view too, but at least from the legal point of view, what are the problems with these hyper risks? Attribution becomes a major issue. Conditional law was easy to understand and attribute. My cow is gone and he's on my neighbor's farm. I can make a little narrative in my mind and explain to a judge, I think he came in the night and took the cow and took it to his farm. We understand the problem. We understand who's at fault, who's to blame, what to do about it. But now, hyper risks are spatially and temporally and socially, in terms of the sheer number of actors, so dispersed. We can't narrate this in a meaningful way. We can't make meaning of the dangers that we face. If something I'm also interested in is sinking islands because of sea level rise, we can sort of understand the problem, but how do we translate that into a legal problem? Who do you take to court? What is the compensation? What are the damages? It's too complex for this millennia-old system of legal storytelling that we have. I try to explain, or one of the solutions that seem to have occurred or been proposed, and that from my conversations with colleagues seems like a very likely answer that society is going to have for these hyper problems or hyper risks, is insurance. Massive no-fault compensation schemes. I took inspiration of this from a colleague who works specifically on the problem of self-driving cars and the legal problems around that. And the solution after 10 years of having conferences about this was, we're going to have massive insurance for this, which works. It's better than nothing, but it's not a very satisfying legal solution. But yes, what do you do? The people who lose their homes because of sea level rise need to get compensated, right? And I call this actuarial observation because it's not drawing on a theorist, a French legal theorist, Francois Ewald. He says risk is something created by actuaries. Risk is not, and Luhmann also says this, but risk is not ontologically, objectively out there. It's something, in Luhmannian words, it's observed by the insurer and created by the insurer. He observes the risk, calculates, enumerates the risk, who's the victims, how much should they be compensated, and so on. It's a mode of observation, and I call it actuarial observation, but it's also fictive, right? It's not, actuarial observation only works not through actual cases, but through creating averages, average person, average damages, the odds of risks being placed. It's about standardization. It works because it's not individualized, as law has tended to do. Here I've got the thing about self-driving cars. An actual reason works when the person is replaced by an average or the average person. And individuality is displaced and replaced by the systemic level of observation. Now, what are the implications of this? And I think this is kind of the question that I think in my presentations and in my articles, I never come with solutions. I always only come with what is Winston Churchill's address to Parliament when he was elected in England. He said, "My fellow countrymen, I don't bring you peace, I bring you blood, sweat, and tears," or something like that. And I'm always bringing blood, sweat, and tears. But so what are the questions or the implications of this actuarial turn? First of all, in decision programming, the lawyer works with conditional programs. The actuary, which is also my kind of invention, come to think of it, works on conditional decision making. Not conditional, purposive decision making. Temporality shifts from backwards looking to forwards looking. Subject changes from individual to the collective. Blame and sanction is replaced with, it's in the name, no-fault compensation schemes. No one is punished. We just try to take care of victims. In conclusion, so what does this mean for law and for legal theory? I don't know, and if anyone has clues for me, I would appreciate that. But the one thing that I thought, if the algorithmic norms and the algorithms of technology and society and these big consequences of that, if they come together and we have this kind of algonormativity, which I'm perhaps using in a different way than we've been using it so far, but I have a feeling that the law then becomes the object of observation of an insurance system, of the actuarial gaze. What I mean by that, the actuaries. We don't start with the law. Actuaries look, what are the results we want, and how do we correlate and calibrate and fix and tune a wheel here and press a button there so that the law gets us to the result that we want, to the goal that we want. So the main actor, the subject, is insurance, not the law. The relationship becomes switched, and the law becomes training data for this kind of social algorithm. And the typical thing of legitimation through procedure in law is replaced. That's my last point there, is the law then becomes legitimate, not because we can count on the procedure, on the conditional form being consistently applied. The law is then legitimated to the extent that it's serving the goal that we want. So it's sometimes in English people say it's the tail wagging the dog, in a sense. So I think there's much more I could say, but maybe I've said enough for now, and I will end there, and we can discuss. Thank you.